All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Thank you. You may be seated. We are here this morning in a special action arising from Superior Court number CV 2013-052880. These proceedings are being audio and video recorded, and we would ask you to identify yourself and your client when you begin your argument. Each side will have 20 minutes. Plaintiff can reserve whatever time they'd like for rebuttal. We have read the petition and the response, as well as the request for stay, and we've conferenced this matter. And with that, plaintiff, you may begin.
Good morning, Your Honors. Carolyn Goldman, appearing for Mark Goldman on behalf of the petitioners. Your Honors, if it please the Court, I will first address why special action jurisdiction of this case should be accepted. This case involves improper use of the partition statute. It involves questions of statutory interpretation. It involves pure issues of law. The trial court relied solely upon the partition statute, but did not follow the statutory scheme. Therefore, the trial court exceeded its legal authority in accordance with Rule 3B of the Rules of Special Actions.
Can you tell me why this is even an appropriate case for partition? I mean, should the partition statute come into play here at all?
No, Your Honor, it should not.
Okay.
All of the parties in this case have written agreements pertaining to each property.
Well, I understand you disagree with the court's interpretation of that agreement, but somehow the partition statute was brought into this action.
Yes, Your Honor.
Let's assume for a moment that the trial court's interpretation of the agreement was correct, just for the sake of argument. Should the partition statute then come into play?
Well, if the agreements do not apply, then the parties own the property in common, and I guess arguably it would apply then.
Would that be a remedy? What would that remedy look like in a way that would be satisfactory to either side? I guess it seems to me, given the nature of this property and the nature of the underlying transactions, a remedy that I can't understand why anyone would want. I can understand why there's disagreement over the disposition of the property and perhaps the relative interests in the property, but would a partition really be what anybody wants?
If the court were to rule that the agreements do not cover the decision to sell the property, our clients would rather have the property partitioned because they would receive the largest share of the property. They are not in disagreement with one another. They want to wait until the market has come back in these various outlying areas in order to sell the properties and to avoid incurring a large loss on the sale. So yes, they would rather have the defendants receive a slice of the property and they would receive the rest of it, and then they could wait maybe a year, 2 years, 3 years, whenever the real estate brokers in those areas advise them is the appropriate time to sell these properties. So yes, Your Honor, they would rather have partition.
And as long as we're on the subject of jurisdiction, has there been a signed judgment in this case?
No, Your Honor.
Ever?
No, sir. No, Your Honor.
On no part of the case? Because I couldn't find one.
There is none, and the parties are not in disagreement that there was no final judgment under 12-2101A1.
I suppose the reason I'm asking is one of the arguments that the respondents have made is that you waited too long and should have appealed some of the interim rulings, but I didn't see any signed judgments with 54B language.
No, Your Honor, there are not. Out of an abundance of caution, I filed a notice of appeal of the February 19th, 2015 minute entry based on ARS 12-2101A7, which pertains very specifically to interlocutory judgments in any action for partition that determines the rights and interests of the respective parties and directs partition to be made. There are no court decisions interpreting this provision. I think there are arguments either way as to whether it applies. We can't rely on it.
But if you were to proceed with an appeal on that, a traditional appeal, and the proceedings now ongoing with the real estate commissioner were stayed, that would be an adequate remedy, wouldn't it?
With the caveat that two of the properties, the parties agree they want to sell now. Our clients would definitely prefer not to have this real estate salesperson involved. But with a stay and with the proviso that the parties could, if they could agree, to sell these 2 of the 8 properties, yes, Your Honor, that would be.
Okay, thank you.
This case also involves an erroneous ruling that a real estate salesman did not owe fiduciary duties to the owners of the property he was. Should I move on?
As long as you're going to touch on that point, let me just ask you, I didn't see a citation to Mashney v. Foster in your brief, but in a case involving a different sort of master appointed by the court, we did reach a holding that would seem to suggest that a court-appointed special master can't owe a fiduciary duty to anyone because you have 2 different sides with competing interests. Wouldn't that apply to your argument here as well?
I don't think it would, Your Honor. I think that this real estate salesperson should owe fiduciary duties to all of the parties, the petitioners and the respondents. And there are very serious reasons why the courts have always recognized that real estate salespersons and brokers owe the duty of disclosure, the duty of loyalty, the duty of honesty.
When they are retained by a party. But when they are retained by the court to resolve, and we'll get to whether that should have even happened, but when they're retained by the court to help in the resolution of a dispute between parties with competing interests, how does a real estate commissioner fulfill those fiduciary duties if one side wants to sell right now and another side wants to hold out for a higher price? Which side does the duty of loyalty run to?
Well, I think Your Honor's point goes to the duty of obedience. And I deliberately omitted the duty of obedience, which a agent typically owes to his principal, because I do agree in this case that perhaps the real estate commissioner cannot follow the instructions of either party and has to look to the court. But I do believe that they still need to disclose information. That is what keeps people honest, regulation. Otherwise, the real estate broker could set a low price and sell the property very quickly and then obtain his commission very quickly. That's why these duties are in place. He's still, as I gave the example of a court-appointed attorney, that attorney may be appointed by the court, may file reports with the court, but is still supposed to have the client's best interest at heart.
Of course, but that attorney isn't a special master in most cases. There are some cases, I suppose, in the family law arena where the duty does run to the court, but those are very specific.
Are there competing interests, assuming the court's order is upheld that the operating agreement doesn't apply post foreclosure and the property has to be sold? Do the parties have competing interests with regard to the how the person selling the property operates?
Yes, Your Honor.
What are the competing interests?
These properties represent a very significant retirement investment to my clients. They represented in the agreements that they were all sophisticated people with assets of over $500,000. Our clients want to maximize the price. They don't want to lose their investment. At some of these properties, if they were sold today, they would not even bring in what the loan amount was.
But that goes to the point about whether they should be sold. If the court is ordering that they be sold, are there competing interests? Don't both sides want to maximize the value that's obtained?
It doesn't appear so. It seems that the respondents are more concerned with getting the cash out of them and selling them immediately. even if it doesn't bring the best price. They need the money, they need the cash, they want them sold
So in
immediately.
their eyes, that's maximizing value. Minimizing downsides is, in some people's minds, maximizing value, and sometimes that's the better calculation.
It's a difference of opinion, Your Honor.
Is there a disagreement about whether the parcels can be partitioned? Assuming it were going under the partition statute, it seemed to me the first step was to appoint X number of people to decide if the parcels can be partitioned. Is there any disagreement that these could be divided, each parcel could be sold individually?
There's really never been any, decision on that. I really couldn't tell you what the respondent's position is on that, other than I know that they really would rather have the property sold than to have partition. So I think at one point...
I guess my question is whether it would matter if the properties are all sold as one big parcel, or can they all be sold separately?
They really must be sold separately because they're located in very different areas. One is in Harquahala Valley, two are near Prescott, one is in Kingman. They're really all over the valley.
That goes to my first question about whether if the partition statute were to be applied, you would agree that initial step is pretty much unnecessary to decide whether the properties can be partitioned. The appointing is at 3. I'm sorry, I've forgotten the number but whatever the statute requires that you appoint 3 people to decide whether it can be partitioned. That's an unnecessary step?
No, I don't think it's an unnecessary step, Your Honor, because I think someone really would need to, I don't think the parties will be able to agree. So I think that those 3 commissioners would have to sit down, look at each property with a surveyor, and decide which slice could be given to the respondents. What would be the appropriate slice to give them?
Do you think in this case that there's a practical way to slice these parcels up that wouldn't reduce the overall value to all concerned?
Yes, because most of them, actually 7 of the 8 properties are vacant land. 2 of the properties are over 60 acres. So yes, I do.
Okay.
Would you like me to address any particular issue, Your Honors?
That's your argument.
I think I'll hone in on the agreements, Your Honor.
Actually, before you go there, sorry, if there's, it's my understanding that before any sale would take place, that the commissioner would have to provide notice to the parties. Would that provide an adequate opportunity to your clients to object? Would there be an opportunity at that point to challenge a sale? I'm just wondering if this is arguably premature.
Well, at this point, the court has ordered that these properties be sold immediately and listed for sale immediately. So in other words, the trial court skipped all of the steps that would lead to the decision as to whether the properties could be divided, and instead just ordered that the properties be sold.
Well, I think Judge Catani's question is, in light of that, if in fact the commissioner finds someone to buy these properties and intends to do that deal, doesn't he have to give notice of that intent to enter into that agreement, and then the parties would have an opportunity to object and bring that to the court's attention?
You're touching upon a very difficult question, Your Honor, that I'm not sure I really want to bring up, and I don't think I have any choice but to bring it up. As I mentioned in my papers, and the short answer to your question is no, we have no ability to object in the trial court. That's one of the problems here. I filed a motion for a stay pending appeal. I filed motions to ask the judge to reconsider his appointment of this realtor because he didn't have listings that were similar to the properties. He wouldn't turn over his comparable sales so that we could prepare objections. And the trial court held a telephonic status conference and immediately went on the record and didn't let me say anything, threatened me with a criminal order to show cause, criminal charges, and a bar complaint if I continued in my current course of conduct in filing these types of motions. So, Your Honors, I did not sign the special action. My husband and partner did. I literally stand here before you today in jeopardy of criminal charges, a criminal order to show cause, and a bar complaint. And please, Your Honors, don't think that these threats were idle, because Judge LeClaire did issue a criminal order to show cause against an attorney by the name of Vince Montel on February 12th, 2015, and held a criminal hearing regarding that order to show cause on February 13th, 2015, and I can give you the case if you'd like. The
I
judge
guess
was,
my question is just, can't you raise the exact same argument that you're making here today once the commissioner says this is the proposed sale and has to provide notice to everyone? Why could you not go into the court and say we object? If the court overrules your objection, could you not file a special action at that point? Why would it be different than what you've filed today?
well, I really can't. I can't go back to the court and ask the court anything. I've been threatened to be put in jail. My husband, who's very courageous, will do it, but I don't want him put in jail either. The judge has made it very clear that this is what's going to happen. This real estate commissioner is going to sell these properties, and don't object.
Okay,
that was what I was told on March 6th, Your Honors.
Then let's focus on one other issue. What's your position as to the court's power outside the partition statute to appoint a real estate commissioner at all?
I don't think the court has any power. Respondents realize that the
The problem
judge.
isn't this real estate commissioner. The problem is a real estate commissioner.
Both are problems.
Okay, but it's your contention that the court is proceeding in excess of its jurisdiction, not only because it didn't comply technically with the partition statute, but because it has no power to conduct the sale.
Yes, Your Honor. I can't think of any. The respondents realize that the judge didn't follow the partition statute, so now they're trying to argue that he used the Uniform Declaratory Judgment statute and the supplemental authority in connection with that statute, but he cited no cases that would hold that the court has authority pursuant to making a declaratory judgment ruling to order the sale of property, and I haven't found any.
And as I understand it, your position that the court lacks the authority to employ a real estate commissioner is really independent of whether you win or lose on the issue of the binding effect of the agreement post-foreclosure. Would that be a fair statement?
You know, I apologize, Your Honor. I'm not quite sure what the question is.
Okay. Are you contending that whether you win or lose on the interpretation of the agreement, the court doesn't have the power to conduct the sale by hiring a real estate commissioner?
That is correct, with the caveat that if the judge followed every step in that partition statute, appointed the three commissioners, and the three commissioners came back to the judge and said, Judge, we just can't find any way to partition these properties, they're incapable of partition, then the judge could order a sale of the properties under the partition statute. But I don't see any other way. I think we have due process, 14th Amendment issues here. There really just isn't any procedure or authority for it. I think the judge is outside his legal authority.
So what's your in your view, what is respondents' what are their options, assuming the court is correct in saying that the properties that they can't simply be held in perpetuity, or that they have to be sold? What available remedies are there for the respondents?
Well, Your Honor, I don't think they really have any, because they signed agreements agreeing to this procedure.
But assuming the court's ruling that the agreement doesn't survive post-foreclosure, then what would their remedy be?
The partition statute, and going through all of the steps and the hoops to see if these properties can be divided.
I have a question going back to your discussion of the stay request at the trial court.
Yes.
That
Sure.
conference was, at least initially, on the record, and the court went off the record to make comments to you and counsel.
Yes, sir.
When you went back on the record, did you make a record of what was said?
I didn't, sir. I was so shocked and flabbergasted. I've learned a lesson. The next time I would, and I don't think I would ever. If a judge asked me, unfortunately, I was very trusting. If the judge asked me to go off the record, I wouldn't do it. I'd say, no, sir, I'm not going off the record. We have to put this on the record. I don't think that there's any dispute as to what happened. I filed an affidavit in the trial court in connection with a motion we filed in front of the civil presiding judge to remove Judge LeClaire. I filed an affidavit. My husband happened to be in our library when the call was ongoing. He filed an affidavit as to what was said. My affidavit was provided to you. Respondents may have provided the entire motion and my husband's affidavit with his papers.
What was the date of the conversation?
Sir, it was March 6, 2015. A lot of these papers have now been sealed by the trial court. They're not obtainable.
Did you file a complaint with the Judicial Conduct Commission?
Yes, sir, we have, unfortunately. I'm sorry to say we have. And do you have any other questions for me, Your Honor?
Not at this time. You may
I
want
see
to
my-
save a few seconds for rebuttal.
Okay, thank you, sir.
Good morning. May it please the court, I'm Glenn Hotchkiss. I represent Mark Spino, who is with me at council table, his wife Rhonda Lalonde, and their investment entities, who were the defendants, counterclaimants, and third-party plaintiffs in the trial court below, and who are the real parties in interest in this special action. I'd like to first briefly address the jurisdictional issue and explain to you the key reasons why I believe the panel should not exercise special action jurisdiction in this matter. First, petitioners characterize the September 8th, 2014 minute entry as a partition order. They've acknowledged here today in argument that ARS Section 122101A7 allows for an interlocutory appeal of a partition order. They did not take that direct appeal when it was available to them back in September of last year.
So, but there is no case law that I'm aware of interpreting that statute as providing the only opportunity to appeal. And I'll give you an analogy. The statutes also allow a direct appeal of the denial of a motion for preliminary injunction. But I'm not familiar with any case, in fact my belief is to the contrary, that would say that a lawyer can't appeal at the end of a case when a preliminary injunction was denied in the middle of the case. The lawyer can still wait for the final judgment and appeal the whole case, right?
As a general rule, that's true.
And there's no authority suggesting that they can't now, especially when there has not been a single signed appealable order in the history of this case, and certainly not one with Rule 54B language.
You're absolutely right when you talk about the right of a direct appeal. But we're talking here about special action relief and review. And the Supreme Court's case in the Neely decision, which I cited in my response brief, states that if an interlocutory appeal is available but not taken, the Court of Appeals lacks subject matter jurisdiction to later review that very same order by way of special action. Doesn't mean they don't have a direct appeal when this case is over of all of the orders in this case. They do. The question today, though, is should this court exercise special action jurisdiction? And what I'm saying is, to the extent that they're right, that the September 8th, 2014 minute entry was a partition order, then the Neely case requires that you decline special action jurisdiction because you wouldn't have subject matter jurisdiction. That's the first reason I think that you should decline special action jurisdiction. The second is, and you touched on this, Judge Swan, there were 4 prior orders that were issued between 6 and 9 months ago that deal directly with the subject of selling these properties. First, in its order dated July 10th, the court ordered the parties to discuss the terms of listing these properties for sale. Obviously, the court did that because it had decided by that point that the properties needed to be listed for sale.
Why is that obvious?
Why would
Trial
you?
judges all the time direct parties to discuss reaching agreements. The
But this
rules
ag-
encourage that.
Absolutely. But this agreement was to list the properties for sale. It wasn't just to agree to sell the properties. It was sit down and discuss the terms of the listing agreement.
I'm sure you've heard the speech 1,000 times, and I've given it 10,000 times, that there are things the parties can do by way of settlement that the court cannot do by way of order. And the parties can agree to sell their property anytime they want. What I'm concerned with is how it is, under what legal authority the court decided to run this sale itself and employ special masters to do it. because while that can happen in a quasi-in rem proceeding like a family court estate, I'm not aware of any civil authority that gives the court the kind of power it appears to be exercising here.
Your question, Judge Swan, leads me to discuss a critical distinction here, which is the difference between a partition in kind and a partition by sale. There are two types of partitions, and when you talk about partition generically, it's important to distinguish the two. All of the statutes that my opposing counsel says the trial court was obligated to follow but did not are statutes that go to the remedy of partition in kind. That is not even applicable in this case, and here's why. My clients filed 8 counterclaims for partition, 1 for each of the subject properties, but they are counterclaims for partition by sale. You can tell that because they're specifically denominated as such in the counterclaims, which are Exhibit 16 to Plaintiff's Appendix. We have never sought to have these properties divided or partitioned in kind. We have only sought to have them sold. The statutory authority to do that is found in ARS Section 12-1218. Subsection A talks about if the commissioners determine that the property cannot be partitioned in kind, then the court can go ahead and say the property is incapable of partition. Subsection B says, and I'm going to read this because this is the critical section with regard to the partition issue. If on the trial of the action it appears to the court that fair partition of the property cannot be made without depreciating the value thereof, or that for any reason a sale is more beneficial to the parties or any of them, it shall in the first instance enter a judgment directing the real property to be sold. Couple key points there. First of all, that remedy of ordering a sale is not conditioned on a prior finding that the property is incapable of partition in kind. The clause that says, or that for any reason a sale is more beneficial to the parties or any of them, allows the court, after hearing the evidence, to decide that a sale of the property makes more sense. And that's exactly what Judge LeClaire did here after hearing all of the evidence at the April 1st, 2014 evidentiary hearing.
I understand that. In a judgment ordering the sale, it sounds to me that that's as far as the trial court should properly have gone. I don't see where the trial court has the authority to run the sale.
Let me address that directly.
Okay.
ARS Section 12-1218C says, the court shall appoint a commissioner to make the sale provided by subsection B. And then it goes on to say, such commissioner shall sell the real property in the time and manner after notice as directed by the court. So what that means is if the court determines to order a sale of the property as opposed to a partition in kind, it then is obligated to appoint a single real estate commissioner, not 3, 1, to sell the property, at which point the commissioner is directed to sell the property in the time and manner as directed by the court. That is the exact authority that Judge LeClaire cited in his September 8th, 2014 minute entry appointing Lee Kopelman to sell these properties. He cited to both sections 12-1218B for the proposition that the properties were ordered to be sold, and he cited to subsection C as his authority to appoint Lee Kopelman to sell the properties. That is the legal authority on which the trial court was entitled to do exactly what it did. Bottom line here is that the trial court did comply with the partition statutes, and all of the arguments to the contrary that are made by opposing counsel confuse the separate concepts of partition in kind, which was never in play in this case, and partition by sale.
So, assuming that order gets reduced to a final order that's signed by the court, that becomes appealable? Would that be an appealable order at that point?
And I assume you mean, Your Honor, that it's something less than a final judgment disposing of all issues in the case. Because if it's the latter, yes, of course it would be appealable. But if it disposes of less than all issues in the case, it would be an appealable order under ARS Section 12-2101A7, yes.
Just trying to understand what remedy your opponents would have to deal with that?
They have a remedy by way of direct appeal, either upon entry of the type of judgment that you're talking about under ARS 2101A7, or the traditional remedy of a direct appeal at the conclusion of this case. And to speak to that issue for just a moment, where we are in the case below is the trial court has awarded fees to my clients. We have filed a supplemental fee application to pick up from where the prior fee application left off last November. That has, to my knowledge, not been opposed. We expect a ruling on that supplemental fee application and the entry of a final judgment imminently. And by imminently, I mean within the next 30 days.
Is it your client's position that all of the properties need to be sold? Is there some reason that all of them, as opposed to, say, 2 of them, need to be sold? Can their interest in the properties be satisfied short of selling all of the properties?
The answer to that is that the reasons that the properties need to be sold are not property specific. So there is no distinction, in my client's mind at least, between any one of the 8 properties and the remaining 7. What I mean by that is our interpretation of the beneficiary operating agreements, which the trial court wholeheartedly adopted, was that because the BOAs are largely silent, as the court said, in the post-foreclosure scenario, they simply don't govern what should happen in the event that the parties take back these properties through foreclosure. There's nothing in the BOAs that allows the majority rule provision to allow the majority of co-owners to decide whether, when, and on what terms to sell these properties. It would have been very easy to put that language in the BOAs, but it's not there.
Can I take you back, though, to the statutory analysis?
Sure.
I've been looking at the statute you cited in the earlier sections, and it all seems to hinge on a report of commissioners, plural, as contemplated in the first physical partition statute, and then refers to a trial after receiving the report of the commissioners, plural. The report and the duties of the commissioners refers not only to them in the plural, but also to their power to make decisions by majority. I'm not seeing any statutory authority for the process that the court used here.
This is going to require a grammatical analysis.
I'm up for it.
Okay. If you look at subsection B, it says, if on the trial of the action, comma, and then it talks about it appearing to the court that a fair partition can't be made. Then there's another comma, and it says, or that for any reason a sale is more beneficial to the parties or any of them, the court shall in the first instance enter a judgment directing the real properties to be sold.
Sure, but this all assumes that we get through subsection A, which again seems to incorporate the entire statutory scheme which contemplates the use of multiple commissioners.
But actually it doesn't say that. There's nothing in subsection B that says, in the event that the commissioners determine the property can't be sold, then in that event and only then can the court order the properties to be sold. I'm sorry. It doesn't say that an order for sale must be conditioned on a finding that the properties cannot be partitioned in kind.
So you read B as a completely independent statute that allows the court to proceed to trial without any commissioner's report, despite the fact that A refers to the report or the opinion of the commissioners.
I do, and here's why. Again, we never sought partition in kind. And there's nothing in the partition statutes that says you first have to go through the hoops of trying to partition the property in kind before you can get an order for partition by sale. The statute simply doesn't say that.
Well, to the extent that we're going to get down to the level of where the commas are placed, I would submit that the question of singular and plural also deserves some consideration, doesn't it?
I understand your analysis, Your Honor.
I'm not saying it's my analysis. I'm just exploring it with you.
I understand your point, and I wouldn't necessarily say that's wrong. Let me turn to an alternative basis for the court's decision.
Okay.
Because
First, can I ask you, do you agree
Yes.
with opposing counsel that these There's nothing unique about the properties that would dictate that all of them have to be sold at once, that each of these separate parcels can be sold, that there's no need to go into a judicial determination of boundaries or how to divide up the parcels before they're sold?
I do agree with that. We've been pressing, obviously, for sale of these properties, not only throughout the pendency of this case, but even before that. And I have always said that a sale of the properties can happen on a property-by-property basis. In other words, because what we have here are different groups of plaintiffs and defendants co-owning each of these 8 properties. And so the decision whether to sell a given property necessarily is independent of the decision to sell any of the other 7 properties, just because you have different co-owners. So yes, I don't think the properties have to be combined for sale. They can be sold individually, absolutely.
And is there a dispute as to how much obviously there is a dispute how much they're currently worth, but there haven't been negotiations about selling X parcels, paying off your clients and leaving the remaining parcels to increase in value, or in anticipation that they might increase in value?
My client indicated as to at least one of the properties, it may be more, before this case was brought, that he'd be willing to sell out his interest for the sake of allowing the other co-owners to continue to hold the property. That was turned back on him as essentially blackmailing the other owners into buying him out. That wasn't his thinking at all. His thinking was, I'm a tenant in common. I have an independent decision to make as to whether to sell or hold these properties. All of you want to hold, I want to sell, buy me out.
Has that been explored after the court's ruling that the operating agreement doesn't apply post-foreclosure?
It has not. Since that declaratory ruling, Your Honor, I made extensive efforts to ascertain plaintiff's position through Ms. Goldman about whether these plaintiffs are willing to sell on a property-by-property basis. I was repeatedly told that she was polling her clients and she'd get back to me. Ultimately, she never did get back to me, and the plaintiffs have never been willing, or at least expressed any willingness, to pursue a sale remedy. They have taken the position, as she said in her remarks this morning, they want to hold out until the property values come back to the point when they will get all their money out of their investment. Many of these properties, most of them are raw land in outlying areas. That's going to take years to happen. My client, to your point, Judge Swan, wants to cut his losses and put his money in a better investment opportunity instead of having his money sunk into a property that is stagnant, has no market, no foreseeable future, and into which he's having to put money.
My quarrel isn't with the relative wisdom of one party's investment strategy over the other. I'm just concerned that the court act within its jurisdiction according to statute. And I keep coming back to this statutory scheme that says, let's say we get to the point where the court enters a judgment directing partition. It doesn't say which kind of partition, but we're talking now about ARS 12-12-15.
Which would be partition in kind.
Well, where's the part about the other kind of partition? Because 12-12-15 follows on 12-12-11, which is the statute that defines the entire partition process, tells you what has to be in the complaint, and defines the scope of the remedy, right? So I'm not seeing in this statutory scheme exceptions to the process for different kinds of partition. Nowhere does the legislature seem to mention that.
Well, the authority for a sale as opposed to a partition in kind in the property is ARS 12-12-18B.
So when the statute giving the court authority to enter judgment requires the appointment of commissioners, and then 12-12-18 talks about what those commissioners are supposed to do, we can simply take a sentence out of the statute and assume that it creates an entirely different process, an entirely different remedy, just because that one sentence doesn't mention the word commissioners. It seems strange to bury an entire doctrine in a sentence in a subsection of a statute that's part of a series of statutes defining a cause of action, doesn't it?
I understand your point, but the legislature obviously had something in mind in saying in subsection B that if the court determines that for any reason it's more beneficial to sell the properties, it can order a sale. It obviously had that in mind as a remedy not independent of, in addition to partition in kind.
Oh, there's no question that that statement is correct. I don't think anybody could argue with that. The question is whether the procedural protections that are designed to precede the actual sale fail to apply because it's a sale and not a partition in kind. That's where I'm not seeing the statutory language.
Understood. Part of the answer to that question is, as the trial court found in its July 10th, 2014 minute entry, plaintiffs failed to present any evidence of partition. None of the parties have ever treated this as a partition in kind case until after the court ruled that the properties be sold. At that point, that's only then was when plaintiffs started complaining about you didn't follow the statutory procedures. And the court's response to that, when they belatedly said, time out, wait, we have a partition procedure we have to follow here, the trial court said, well, where have you been? I heard a half day of evidence on April 1st, and you didn't present any evidence of partition. And as Ms. Goldman concedes, we haven't pursued partition in kind. This has never been a partition in kind case. I see that I'm out of time. Let me briefly mention the alternative legal basis for the court's finding, which is, in its September 18th, 2013 declaratory ruling, the court said the majority cannot require my clients to continue to hold these properties indefinitely over their objection. The only logical conclusion from that is that the properties have to be sold. When I couldn't get the plaintiffs to agree to a sale, I filed an application for order to show cause that relied on ARS section 1838, I believe it is. And that section says if a court has issued a declaratory ruling, it has the right to supplement that declaratory ruling by ordering other relief, that's the statutory term, other relief to make meaningful the previously issued declaratory ruling. And so what we ask the court to do is to make meaningful its declaratory ruling by ordering a sale of the property.
And see, wouldn't that be the more procedurally appropriate way to go? Because then you don't worry about the partition statutes at all. The court simply enters an injunction saying owners, co-owners, sell the property, signs the judgment, and then there can be an appeal. Isn't that the way the system's designed to work?
And that is exactly why in the application for order to show cause I filed, I relied exclusively on the declaratory judgment statutes and this supplemental relief provision and never even cited the partition statutes. The problem we've got is that what the trial court did in ordering a sale of the property was to cite to the partition statutes and not the declaratory judgment statutes, which causes some confusion as to...
It's a problem.
Well, it is a problem in the sense that it causes confusion as to what legal basis was the court using to order a sale of the properties. But here's the relevant point. As the panel is well aware, if there is an independent legal basis to support the result in the trial court, this court can uphold the trial court's ruling on that alternative legal basis, which here is the declaratory judgment statutes, even if it thinks the trial court was wrong with the legal reasoning that it used. And I would submit that even if you conclude that the trial court erred by not following the partition in kind statutes, which necessarily is a precondition to ordering a sale, you still can and should affirm on the basis of the declaratory judgment supplemental relief statute, which provides an independent legal basis for what the court did.
Well, we're not in a position to reverse or affirm on special action, but if we were to take that view, then the trial court would have to perform certain steps that may be purely ministerial at this point, like entering a judgment, right?
Well, absolutely. At a minimum, the court needs to enter a judgment because the case in the trial court's not over. But if what you're suggesting is that if you agreed with my reasoning, wouldn't you have to remand for some further proceedings in the trial court, including the entry of a judgment? Yes, I agree with you.
Okay, thank you.
Counsel, we'll add 2 minutes to your rebuttal time. We've gone over a little bit.
Thank you, Your Honor. May it please the Court. First, the Uniform Declaratory Judgment Statute does not provide any authority for a trial court to order the sale of property ancillary to making a decision on a contract. I have researched this. I have found no cases. There are insurance cases in which the court has found an insurance contract covering a particular matter and then awarded a money judgment, but there are no cases giving a court the authority to sell the property.
Sorry, go ahead. Well, I'm just going to ask if you're suggesting that the court should have followed the partition statute, should have appointed 3 commissioners, what in your view would the 3 commissioners, what would the result of the commissioners' work be? Is there any conclusion other than they would say these parcels can be divided, they are separate parcels, they can each be sold individually? Why go through that step if it's a foregone conclusion what they would determine?
Oh, I think the commissioners, Your Honor, could decide that the properties can be divided. Oh, I think the commissioners could very well make that decision.
So why do we need to go through that step? Why does the court need to appoint 3 commissioners to?
Well, because, Your Honor, then my client's property wouldn't be sold out from under them. Mr. Spino would get a slice, and my clients would get the other large part of the property, and they would get to hold it as long as they wanted. That would be the end result. There would be no sale.
Is there anything legally wrong? Keep in mind, we're here on special action, and I understand that the main complaint here is the trial court's interpretation of the parties' agreement. But is there anything to keep the trial court from proceeding with a declaratory judgment that interprets the agreement, an injunction that enforces that interpretation, followed by an appeal that seeks review of that interpretation? And procedurally, that seems like the way this ought to go. Do you disagree with opposing counsel on that point?
A mandatory injunction, Your Honor, that the properties would be sold now or a stay?
Well, in other words, instead of the court assuming control of the sale process, the court simply orders the parties through a mandatory injunction to get them sold. And if the parties are dissatisfied with that order, they appeal. Isn't that the normal procedure?
Well, certainly a mandatory injunction would be a very serious remedy. We would argue that there could be irreparable harm to our clients because of the real property being involved, and damages are typically inadequate. In that type of scenario, we would certainly ask for a stay until the appeal had been decided. And I'll go back to my earlier argument. I don't think the Uniform Declaratory Judgment Statute gives that authority. One of your honors had asked, why don't the parties negotiate? Our clients have bought Mr. Spino out of several properties for years, and they're just tired of doing it. They do feel like they're being blackmailed at this point. As far as the...
But assuming the court's order is upheld, that the operating agreement doesn't survive foreclosure, isn't that don't they have to either do that or sell all the properties?
They would rather have partition, Your Honor. They would rather keep the large chunk of the property and hold it. And
why not negotiate to do that?
Well, this is a case with a lot of history. Mr. Spino sued some of my clients for securities fraud, dismissed that case with no settlement whatsoever for $0. So they have a long and unfortunate history, and negotiating is difficult at this point. There's not a lot of mutual trust. Although the parties have agreed in principle to sell 2 of the properties.
I understand that there may be some bad blood between the sides, but it can still often be more profitable to negotiate a resolution than to pursue processes like this that can be unpredictable and expensive, time-consuming. Just a thought.
Yes, Your Honor. Just very quickly, the respondents used the partition statute to try to get the property sold. Now they realize they can get stuck with partition or division of the properties, and now they're trying to say that there's a distinction between partition by sale and partition by division. Maybe under the English common law there was, but there isn't in this statute. There is no such thing in this statute that's partition by sale. It simply doesn't exist. Respondent brought up the September 8th, 2014 hearing, and why didn't we bring evidence of partition into play? That hearing was on his order to show cause why our client shouldn't be required to agree to sell the properties. Partition wasn't at issue at that time. There's never been a trial or hearing in this case in which the trial court heard any evidence of partition or whether the properties could be divided. As we discussed earlier, it's completely unclear whether A7 applies to the February 19th, 2015 minute order. It certainly didn't apply to any earlier ones. They were just preliminary and led up to the order to sell the properties.
I think we're out of time.
Thank you, Your
But
Honor,
thank
so
you both
much.
for your argument. We'll take this matter under advisement and issue a decision in due course. With that, we're adjourned.